Good morning, good afternoon, or good evening. Thank you for joining us today. Today we're going to be talking about the recently enacted New York cybersecurity regulation called 23 NYCRR 500. My name is Mitch Tanenbaum. I am a partner in the cybersecurity consulting firm CyberCecurity based in Denver, Colorado. We provide cyber consulting services to a variety of industries across the United States, including the financial industry and their partners. Governor Cuomo announced this new regulation late last year, and it went into effect on March 1st. It is the first in the nation version of a regulation like this. The regulation was first proposed by Ben Lawsky, who was then the superintendent of the Department of Financial Services. He talked with regulators in all 50 states, plus the national regulators, about what he was doing to make sure that he got buy-in and that people weren't going to object to anything he was doing. He got a lot of feedback, and as a result of what's going on here, the regulators in other states are watching this New York regulation to see how they can include that in their state. This regulation affects all organizations that are licensed by the Department of Financial Services. That includes organizations like banks, savings and loans, insurance companies, and other financial institutions. It includes mortgage companies, registered investment advisors, but more importantly, it includes all of their vendors who have access to their data. This likely multiplies the number of people that this impacts by a factor of 10. There are a few exceptions to who's covered, and that is organizations with fewer than 10 employees, including contractors, organizations with less than $5 million in gross revenue in each of the last 3 years, and organizations with less than $10 million in year-end total assets. Now, that doesn't exempt them completely from the regulation. It only completes them from some of the more burdensome parts of the regulation. And obviously, if you are a vendor to a financial institution who is required to comply, it really doesn't matter what your size is. It really is more important what their size is. The regulation went into effect on March 1st of this year. Companies have to be compliant over a staggered period of time. The first compliance date is September 1st of this year, with other compliance dates following at 6-month intervals. What they mean by compliance is that on February 15th or by February 15th of every year, either the chairman of the board or the CEO or some similarly titled person in the organization must personally put his signature on a piece of paper and deliver that to the superintendent of the Department of Financial Services that says that they have reviewed all the documentation and that, to the best of the officer's knowledge, the company is in full compliance with Part 500. There's no place on the form that says we are in compliance except for these few things that we're not in compliance about. What are the consequences? The regulation will be enforced by the superintendent of the Department of Financial Services and will allow him to use whatever laws and regulations exist in New York State to penalize financial institutions. More than likely, if you are a vendor to if you are a vendor to a DFS regulated entity, the fine is going to go to that regulated entity. Now, obviously, they're going to come back to you as a vendor and say, you cost us $1 million and we'd like you to pay us back. So, from that perspective, probably there's no get out of jail free card there, but the fine is actually going to go to the regulated entity. Oftentimes in organizations' cybersecurity programs, there's an intersection between convenience court and security street, and people often take the lower path, convenience court. What this regulation is forcing companies to do is take the other path, security street, in order to be compliant with the regulation. So here are some of the details. The first two sections talk about the introduction of the program, the purpose, and the definitions, and there are a number of definitions that you might want to read. The first active part of the program is Section 2. It has a 6-month fuse, meaning it must be in place by September 1st of 2017. And it says that you have to have a cybersecurity program that identifies and assesses all internal and external risks that may threaten the security or the integrity of non-public information. So this is not only about privacy, but also about making sure that the data has integrity. It protects the covered entity systems and the non-public information stored on those systems from unauthorized access, unauthorized use, or other malicious acts. And it doesn't matter whether these systems are systems in the cloud. For example, if you're hosted at Amazon, then that means that those components that are hosted at Amazon also need to be compliant. The program needs to give you the ability to detect cybersecurity events, to mitigate those events, to recover from those events and restore normal operations, and to fulfill applicable regulatory requirements. In addition to that, all documentation related to the program and information that you store must be made available to DFS upon request. So be careful what you document, because the DFS folks may ask you for it. The next section, which also has a 6-month fuse, is Cybersecurity Policies. The regulation enumerates 14 very specific policies. It includes a risk assessment policy, an incident response policy, and others. And while the precise content of each policy is not specified, the fact that you have to have an incident response policy, for example, sort of indicates what the content needs to be. The next section, Section 4A, also required to be in place within the first 6 months of the regulation taking effect, is that you must have a designated, qualified person responsible for the overseeing and implementation of the Section 2 Information Security Program. Normally that person would have the title of Chief Information Security Officer, but in one of the modifications to the draft regulation, they removed the requirement that the person have that title. The person may be an employee or may be outsourced, and for smaller companies, outsourcing this to a virtual CISO service provider makes a lot of sense. If outsourced, however, the entity is still responsible. You don't have any get-out-of-jail-free card as a result of that. And if outsourced, the provider must also have their own cybersecurity program that protects the covered entity and their data. The person, as I said, is not required to have the title of CISO. The next part of Section 4, required to be in place by actually February 15th of 2018, is a written report to the board of directors or the C-suite that reports on the state of the cybersecurity program and the cyber risk the organization is facing. Needs to talk about how you're protecting the confidentiality of non-public information, how you're protecting the integrity and the security of the covered entity systems, the cybersecurity policies and procedures that you have in place, any material cyber risks, and remember this report is going to be available to DFS, overall effectiveness of the program, and any material cybersecurity events that have occurred since the last report. Section 5, which must be in place in 12 months, says that you have to have penetration tests and vulnerability assessments in order to monitor the risk of the program. It says pen tests are either annual or on a continuing basis. If you do continuous monitoring, that's acceptable as well. And biannual vulnerability assessments. And this is all tied to the risk assessment, which we'll talk about in a minute, but that means that the risk assessment must be implemented sooner rather than later in order to be able to drive some of these other requirements. Section 6, also a 12-month lead time, talks about audit trails. The audit trails must be designed to reconstruct material transactions in order to be able to support normal obligations and to be able to detect and respond to cybersecurity events. For most organizations, this means a significant increase in the amount of audit data that you are collecting, because in order to be able to reconstruct an event and to be able to respond to an attack, you need much more information than most organizations typically have. In addition to that, these audit records must be maintained for at least 5 years. Many organizations will need to step up their storage capability in order to be able to store these audit records for 5 years. Good news is that disk drives are cheap. Cloud storage is even cheaper, and you're going to be using a fair amount of it. Section 7, which must be in place within 6 months, talks about access privileges, which means that the organization needs to have a formal, structured, and enforced plan to limit user access to non-public information, and that access must be reviewed periodically. Section 8, which is a little bit longer, lead time 18 months, talks about application security. This is a huge risk. Organizations need to have written procedures, guidelines, and standards, and use a security development lifecycle practice both for in-house developed software and for outsourced software. And must have procedures for evaluating, assessing, and testing that externally developed software. And that includes whether that software comes from Microsoft or Oracle or anybody else, or is being done under contract to you for your own use. And these application security processes must be reviewed and updated periodically by the CISO. Section 9, which also needs to be in place by March 1st of 2018, is a risk assessment. Now, the challenge here is that you're reporting to the board on February 15th, and you're using this to go off and drive other components to the program. So I wouldn't recommend waiting until March 1st to get this in place. But you must conduct a periodic risk assessment sufficient to inform the design of the program. So again, they're not telling you exactly what that program needs to look like. It needs to be in accordance with the written policies and procedures, and it needs to just identify how those risks will be mitigated or acceptance, and it drives the rest of the program. So our recommendation is start it now. Section 10 also needs to be in place within 6 months. Says that you need to have appropriately trained, qualified, internal, affiliated, or third-party cybersecurity personnel, and that you must have cyber risk intelligence information available to you. That means, and there's a number of sources. Some of them are free, some of them are very inexpensive, but fundamentally they're saying you need to understand that there's risks out there, and you need to be aware of the risks in close to real time as you can be, so that you can respond to those risks. You must provide, if the process is staffed with in-house people, you must provide cybersecurity training, and as I said, obtain current threat intelligence. Section 11, which is the longest lead time, is in 24 months. It says that you must have a third-party service provider security policy. And the reason why this has such a long lead time is, for most organizations, it's going to take quite a while to put together a program and then evaluate the security practices of all of their vendors that have access to their data. For larger organizations, this could be hundreds or maybe even thousands of vendors. For example, for mortgage companies who are required to be compliant with this, it includes all of the title companies that they use to close loans, or all of the law offices that they use to close loans. So we're talking about a significant population of people. You need to have written policies and procedures that ensure that the non-public information that is held by or is accessible by third parties is secure, and the integrity of that data is maintained. There's a long list of details, and includes things like cloud loan origination system vendors, Google, Microsoft, and other cloud-based providers. Section 12, which has a 12-month requirement, says that you must use multi-factor authentication. There's a little bit of wiggle room here in that it says it's based on risk assessment, but the person who's doing the risk assessment is probably not going to go off and say, nah, you don't have any risk, not a problem. So you want to use the two-factor authentication or multi-factor authentication to protect against unauthorized access to NPI, and it is required for all remote access to the company's internal network. If for some reason this is not possible, the CISO may approve alternate controls in writing, but again, then that liability falls on the CISO's shoulders to make sure that whatever you're doing instead of multi-factor authentication provides an equivalent level of security. Section 13, which has an 18-month timeline, says that there's a requirement to limit your data retention. Obviously, data that doesn't exist can't be hacked, but on the other hand, you need to go off and look and see what regulatory requirements may be in place that may require you to save data. So what they want is that you have a policy and procedures for the secure disposal of NPI that's no longer needed. They want you to actually look at the data and think about, well, I need this data, but I don't need that data, so I'm going to get rid of that data. And as I said, it doesn't supersede any existing data retention laws, and it doesn't dictate the details like many of the things in this document. Section 14, which also has a 12-month timeline, talks about training and monitoring. It requires that you have policies and procedures for monitoring the activity of authorized users. For most organizations, this does not exist. So if you go look at what you have internally today, what do you have in terms of policies and procedures that monitor the activities of authorized users? You need to be able to detect unauthorized access by authorized users, unauthorized use, or tampering with non-public information. And it requires training for all personnel to be updated based on the results of the risk assessment. So this training needs to be dynamic. One of the key areas that needs to be included in this is training on email phishing. Section 15, which has an 18-month timeline. This is something, the timeline was extended from the original draft because of the complexity of this. This requires encryption of all non-public information, both in motion and at rest. Based on the risk assessment, you need to place controls on the NPI, including encryption. And if it's infeasible, then compensating controls may be approved in writing by the CISO, but those compensating controls must be reviewed and reapproved annually. So they're clearly saying that encryption is the preferred mechanism. But if you can't do that, then maybe there's some other alternatives. This includes things like databases, things like fax servers, and anything where there's likely to be non-public information that needs to be protected. Section 16, which has a 6-month timeline, says that you must have a written incident response plan. It must be designed to promptly respond to and recover from a material event. Unfortunately, the definition of material is not defined, but anything that affects the integrity or confidentiality of data or the operation of the organization would certainly fall into the category of material. The plan has to include the roles, responsibilities, and decision-making, communications, reporting, and documentation of how you're handling an incident, and you need to review and revise the plan as needed, especially after you use it. Section 17, which has a 6-month fuse, talks about the notice to DFS. It says that you must have a process in place to notify the Department of Financial Services within 72 hours of an event. Now, if you are a vendor to a regulated entity, you're likely going to go off and report that event to the regulated entity, and the regulated entity is going to go report that to DFS. But they're going to want that within 72 hours because they're required to report it to DFS in 72 hours. You're also required to notify DFS anytime you have to notify any other regulator. So, for example, if you have a payment card breach, a credit card breach, and you're required to notify the state's attorney general, like you are in many states, or if you have some other privacy breach, including a paper-based privacy breach, you lost file folders, then and you're in a state where you're required to notify either the attorney general or some similar person, or you're required to notify the public, then in this case you're also required to notify the Department of Financial Services, again within 72 hours. And of course it's related to how much harm the event might cause, so material harm, but it doesn't say what material harm is. You're required to keep an annual compliance report to the DFS and keep all documentation for 5 years. Material improvement needs and remediation documentation, which means sort of where the problems are and how you're remediating those, also need to be available to DFS on request. Some of the other sections probably less important, but it does talk about the fact that this is exempt from Freedom of Information Act type disclosures, that if one of the clauses is invalidated, it will be removed, but the other clauses still remain in effect. And with that, we're pretty much have covered things. Unfortunately, there is no easy way out of this. This is going to require a lot of hard work with a very short timeline. The first roughly a half a dozen items are due by September 1st of 2017, and that's not very far along. Please feel free to contact one of us, either myself or Ray Hutchins, the other partner in cybersecurity. And if you want our free weekly newsletter, send us an email and we will add you to our security newsletter. Thank you for spending your time with us today. And if you have any questions, please reach out to us. Have a great rest of your day.